I don't know what more of no tolerance you don't get. Your device has been dead.
So Judge, I don't think it was low and then it went dead for, I think, a couple of days, but he didn't receive, well, I understand that, Judge, but he didn't receive, I guess the device supposed to send something.
You know when you're supposed to charge the device. You know.
I think it gives you a notice or something that is dying out. And so it didn't give him notice. So he went to pretrial service to have him check it out to find out what was going on with it. But he's been on bond for a very long period of time with no issues whatsoever.
That doesn't give you the...
Right here, Judge Fleischer is laying down what we call judicial authority in motion. You can hear the impatience when she says, unacceptable. That's not just frustration. That's a signal to everyone in the courtroom that compliance with bond conditions isn't negotiable. What do you think? Should a dead monitoring device automatically mean jail time, or does intent matter more?
Justification to do what you're doing.
Judge, I will say that I've contacted the device people over at 49, whenever he reported yesterday. They stated like
He only reported yesterday.
yes, we observed.
Unacceptable. Unacceptable.
Well, no, Judge, he reported because I told him that the device, that this was filed. That's the only reason why he reported over there.
The only reason he cared enough to go was because you told him he had to come to court. Otherwise, it would still be dead. It would still be non-functional.
I don't think that's the case, Judge, because it's been functional the entire time that he's had the device. So this is not he's been out for 2 months and the device has not been functioning. That's not it. This was just filed 2 days ago.
Because I wanted to take care of it now. And the reason is that he's on probation for a violation of protective order, picks up an assault of a pregnant person, and then picks up another assault of the same person. And he has another assault dismissed, and they're all the same person. And I told you that there was no tolerance in these cases. And I have here that you have a dead battery since 2/10 of... How long was the battery dead?
According to the viewer, I believe it started on the 10th, and then whenever he reported for.
Yes, Judge, that's what I'm saying.
Reported for inspection, we found no issues with the device itself or the charger.
Revoking your bond. Did you go to jail? I'm sorry. Bond conditions, bond conditions. There's no justification, right? 3 open cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
Judge, it went dead on the 10th, and he immediately went in to go have it checked out because he didn't know.
No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out.
That's not how it happened, Judge.
Tell me.
When I got the email, I said, hey, there's an issue possibly with your device. He said, I got no notification whatsoever that it was dead. So I will go down there and check it out to see what's going on. I didn't tell him about a court date because I didn't know about the court date at the time. I got the motion first. Then your letter came after the fact. So he went on his own to have it checked out. So if you look at the records, I mean, he's been out for a while and this just happened. 2 days, that's it, Judge.
They tell you that you're supposed to charge this thing on a daily basis. They tell you that you need to put it by the charger every day for a specific amount of time. And if you don't, the battery goes dead. So you know what you're supposed to do.
I understand that, Judge, but also if the court remembers that he is also keeping a newborn baby, so maybe he put it in. He was tired. I don't know.
It's been dead for 2 days.
It's only been there for 1 day, I believe, Judge, because he went on the 11th, I believe. Today's the 14th.
No, she said yesterday he went. Today's the 14th. That's the
Today's
13th.
14th, I'm sorry, that was the 12th. I don't know why I thought it was the 13th.
So when did he go?
The 12th.
No, the battery goes dead on the 12th. When did he go to pretrial?
He went to pretrial on the 12th, Judge. His battery went dead on the 10th.
Oh, I'm sorry. Okay, battery goes dead on the 10th. Goes to pretrial on the 12th. So he's without a device 2 days. I'm sorry. Goes with you. Just not getting it. I don't know what to tell you, Ms. Jewett, right? There's just no justification. I have 4 kids. You know, it'll take me 2 minutes to put them in front of an iPad for me to go do what I need to do to go wash the dishes, to go take the dog out, to change the litter.
Well, I understand, Judge, but I mean,
There's no excuse. You've got 3 open, very serious cases. And I told him at the outset when he picked up the last violation of protective order, there's no talk. I mean, you must comply strictly. And he's just not doing it.
just gonna just reset it for reconsideration on this bond, maybe 2 weeks, a month.
So here's the deal. You were right. These cases are ripe. They're old. And it's time to do something with them because the thing is, and what I've experienced is that when we take too long with cases, something invariably happens. You know, cases should only last so long because certain people need certain things. And when they're not getting it, they tend to fall in familiar habits. So these are too ripe. Let me see how old these are.
And if you remember, this case was actually transferred over to the,
Irity?
yes,
Right. Now I'm gonna keep it now, just because it's, just too much drama. So the violation case is 256 days old. The new violation case is 136 days old. Is discovery complete in both cases, please?
Yes, one confirm. Sorry, his last name
Newest
is
case is discovery complete.
correct.
yes, and Judge, if you remember, you may not remember, but this is the case where the wife is saying that what occurred is not really what occurred. Remember, this is the toxic case.
And Judge, either way, discovery is complete on the case.
Do you have an offer on these cases?
On the most recent VPO, there is not. Let me see if
Can you please put an offer so we can,
I'll let DVD know that you're requesting that they put an offer on.
please?
Yes, Judge.
And is there an offer on the felony case?
On the felony case, Your Honor, let me see. There is not, Your Honor.
Because the problem, Judge, is they were supposed to be working on the fact that the wife came to court and told the prosecutor she's not participating. So they were going to reeval. That was 2 months ago.
If I may, they did offer him a 2-year deferred upstairs.
Oh, they did?
There, yes, Judge, it's just in the notes, not in the actual, they're having a conversation about going back and forth with the defense attorney on that case.
Okay.
To see what they want to do.
So you're set up there 2/28, okay? We can set the day after if you'd like.
That's fine.
Okay, and then what I would suggest is when we come back, it's, clear.
Notice what just happened. The judge is giving a tough love explanation of accountability. She's not just punishing, she's teaching consequences. These kinds of statements often become the moral core of a courtroom clip like this. If you were in her shoes, would you give another chance or make an example to set a precedent?
Trial time. So we can just put these babies to bed once and for all. And perhaps the felony court will, you guys can make a global resolution. I don't know, but it's, if I don't do what I'm doing now, I'm enabling. And I'm saying it's okay for you to do what you're doing without any consequence. And it's not. He has to understand that there's consequence. This is the 4th time, it's over and it's over and it's over and I can't.
Understood, Judge.
And I understand that you have to zealously advocate and I'm not begrudging you for doing it, right? Certainly not. Of course not. But I can't continue to enable it, So, okay, you got it. Mr. Guzman, how's jail? You're here with your lawyer. Your lawyer's on Zoom. I don't know, the TV's not working, but he's here with you. We have appointed Mr. Duong to represent you. You are on probation in this court for driving while intoxicated. Can you just put that right there in front of him, please? Right there. You recognize that?
Yeah.
Okay. We're going to do probable cause. I'd like to know what happened on so what happened is you're on deferred in this court for the DWI. you picked up a felony possession of a controlled substance. You also picked up an unlawful carrying of a weapon. I have no idea what happened on those cases, so I'm like to hear what happened.
Yes, Judge. On February 11th, 2024, the officer observed a silver Chevy Silverado traveling on the 2400 block of Little York Road in Houston. The officer ran the vehicle and it returned as a white Chevy pickup truck, and the officer knew that the truck in front of him was not white in color. Therefore, the officer initiated a traffic stop. The defendant immediately opened the door and attempted to get out. A high-risk stop was initiated, and the defendant complied with instructions. The defendant was detained, and the officer observed an NL sticker on the vehicle, which the officer knows stands for Mexican State of Nuevo Leon. The officer observed in plain view a glass pipe connected to a plastic bottle from which training experience known to be consistent with drug paraphernalia. The officer located a clear crystal-like substance consistent with meth, and another officer located a handgun behind the passenger seat.
I'm sorry, you picked up with us the unlawful carrying of a weapon. I'm going to find that there's probable cause to go forward with your case. So, John, it looks like felony court is set for the 17th. Do you want to set it perhaps for the day after to see what happens up there?
Sounds good to me, Judge. And then I'll, Mr. Guzman, I'll come by the jail to talk to you further. Okay?
Okay.
I'm ordering you as a condition of your bond on both cases not to drive any vehicle whatsoever for any reason. And they gave you a PR bond on your gun case. I don't know if that was a smart move. You've not made bond on the DWI as it is, so I don't know. We'll see about the PR bond, but do not drive. I don't know if you're going to get out or not. If you do, you will get a GPS monitor because you are a flight risk. I find by clear evidence that you are a flight risk. As a result, you will get a GPS monitor, and I'm also going to give you a curfew from 7 p.m. to 7 a.m. Do you understand? You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, you will go back in.
I haven't. Want a drug test?
Well, I can't while you're in jail.
Okay.
But if you do get out, trust me, Mr. Guzman, you will be tested frequently.
Okay, that's fine with me. I haven't been using drugs.
So what I'd like to do also is do a TRAS to see where we go from here. I don't know, quite frankly, I don't know where we go from here. You're on probation in this court, and I don't know, because what we typically do is we do evaluations to see, because I have clinician on staff to see how we go forward. I know you tell me what, it's like little bunnies jumping in the woods, but the fact remains is that you've picked up a new case. You absconded on our case. We had issues with that. Now we've got issues here of what happened with these cases. So we will have you evaluated to see how we go forward. And I don't know, they may say residential treatment. They may say outpatient treatment. I have no idea, but that's why I have clinicians on staff, because they are better. They have the tools to tell me how to go forward, because Mr. Guzman, I just don't know you.
I'm just trying to get rid of this stuff and get over with. I don't want to be up in here as much as you want to see me up in here.
So if you don't mind setting them up for a TRAS, and then we'll go from there. So John,
The reset date was 3/17, Judge?
no, he's set for February 17th. So next,
Okay, I got you. So he's going to
on Monday, he's set for felony court. So I guess we'll do, the next day, and we'll figure out where we go, huh?
Yeah, I'll have to zoom in, Judge, because I'm out for the rest of next week. So I mean,
Okay, yeah, no issue. No problem. That's why we have it, okay?
so the 18th.
Yes.
Okay, gotcha.
Okay.
All right, Judge. Thanks. All right, Guzman, I'll talk to you.
Later. So do you mind those conditions, please? And we'll have him sign it. All right. All right, man.
All right,
Good luck.
thank you, Judge. Have a good weekend. May I have excuse?
You too, man. Happy Valentine's Day.
You too.
Charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On August 1st, 2024, the officer was dispatched to a disturbance call, and upon arrival, the complainant and security staff stated that the defendant made threats to kill everyone, broke 2 hospital monitors, and was acting aggressive towards the medical staff. The complainant stated the medical staff became scared since the defendant stated, "I will kill you all." The complainant stated she was scared for her life since she did not know what the defendant would do next at that moment.
That doesn't sound right, because I didn't do that.
Give you a lawyer and we can go through this with the lawyer. So did he direct it at a person? Is he directing at the entire world? What?
The statement was only made that "I will kill you all." And it says the complainant stated the medical staff became scared, and the statement was that "I will kill you all." That's all we have from the DMs, Your Honor. And then furthermore, the complainant did state she was the only one at the hospital at the time of the officer's arrival, since the rest of the medical staff had gone through a shift change and she was the only one there. So it's not exactly clear who was there when the statement was made. He just said, "I will kill you all."
All right, so who's it directed to? Just,
I don't even know if that happened.
The DMs does state that the defendant started to act aggressive towards the medical staff.
and
So
I think that's why she was scared, right?
it appears that it could follow on saying the defendant was
This is such a powerful moment the judge dismisses the case for lack of probable cause but still warns the defendant about behavior. That's not something you see in every courtroom. It shows the delicate balance between justice and mercy. Quick poll: do you think this warning will make a difference or fall on deaf ears?
the complainant said she was scared and the medical staff was scared since he stated, "I will kill you all." So it appears that it was directed towards the medical staff as he was acting aggressive towards the medical staff.
It appears.
Because there's just two
A
distinct
hunch.
sentences, Your Honor, where he acted aggressive towards the medical staff and the complainant stated the medical staff became scared since the defendant stated, "I will kill you all."
I thought he did time for that too.
Mr. Mickish, I'm going to find that there's no probable cause to go forward with your case, but you need to be careful.
Yeah.
Scaring people can kind of hurt them. You know what I mean?
Your Honor, I don't.
Don't. Mr. Mickish, patience goes a long way.
Yeah.
You know, when you get upset and when you lose control, that's why we have so many people in jail, because they lose control, they do whatever they want to do, and they don't think, if I do this, what's going to happen? If I say this, what's going to happen? Be careful. All right? All right, just hang tight for me in the back. All right, Ms. Fernandez, you have been given 2 PR bonds, and your case is nearly 250 days old. They are still allowing you to take this plea bargain agreement where if you complete a class, your case will be dismissed. They are giving you only until Monday. So what we will do is we will reset your case until then. If it's not done, we will have to go another route. If you ever miss court again, you will not get any more PR bonds. That will be the 3rd time that you have failed to appear for court, and it will not go well. Do you understand? You have a lawyer. It is your responsibility to stay in touch with the lawyer, and they can always get a hold of us, but there's no excuse. No tolerance anymore. Okay? Good luck.
Thank you.
You were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On February 9th, 2025, the officer was dispatched to an assist the officer call in regards to a shots fired at 1700 Travis Street. The defendant was detained because the officer observed an unidentified individual discharge a firearm, and the defendant was within that group of people. The defendant admitted to the officer that he had 2 ecstasy pills in his right front pocket and that there was an AR pistol in the SUV the defendant was driving. The officer completed a search of the defendant and located 2 methamphetamine pills in his front right pocket, and the defendant informed the officer that he was aware of the AR pistol in the SUV prior to him getting behind the wheel. The officer located the AR pistol on the floor in the 2nd row of the SUV within reach of the driver. The substance was believed to be methamphetamine based on training experience with a weight of 0.61 grams.
Husband, I'm going to find that there's probable cause. Wait a second. He says that the AR is his?
He says he was aware that it was in the vehicle
Miguel,
and it was within his reach in the vehicle.
Whose vehicle is it?
I don't believe it says in the DMs, it says he was driving the vehicle.
How do you put it on him?
Allow me to read the full DMs, Your Honor. Yes, Your Honor. It says that he was driving, so it would be that he was in care custody control because he was operating the vehicle with knowledge that the firearm was in there and it was within his reach, his ability to grab the firearm.
Diego Camacho?
Not. How do we know that how do we know that it was in there while he was driving? How do we know that they didn't put in there after the fact?
The defendant stated that he was aware that the AR pistol was in the vehicle before he got into the driver's seat, before he started driving.
Oh, no. It just said that he was aware. Don't add stuff in.
I'll read the complete DIM.
Read it.
It says the DIM states completely that the defendant informed the affiant, the officer, he was aware the AR pistol was in the SUV prior to him getting behind the wheel, and the defendant informed the officer that the AR pistol could be found in the SUV at the time of his arrest.
Are we to assume that it's his? All he says that he knew that it was in there. You know, it's not his car.
In Your Honor, just as cited, the pleading is that it was on or about his person. So we're just saying he was in his possession because it was in the vehicle he was operating with knowledge that the AR was in the vehicle as well as it being within
Do you
arm's
even know
reach.
when he was operating the vehicle?
I apologize. What do you mean when he was operating?
Was he operating it in the morning, in the afternoon, at 9 o'clock at night? When did all this transpire? What time of day is this?
Let me see, Your Honor, because based on the DIMs that I see, it appears that
There's a group of people.
it appears
right?
that the defendant was, according to the DIMs, the defendant was found to be at the wheel of a black GMC. So when the officer arrived, he was observed within the vehicle, from what the officer says.
Was in the car at the time
At
the
the
cops
time.
get there.
From what the officer says, that he was observed behind the wheel of the vehicle. To be at the wheel of the black GMC Suburban bearing a license plate number that is in the DIM. So it,
Okay. All right. Your husband, I'm going to find that there's probable cause to go forward with your case. I mean, we take it seriously. I want to make sure if there's enough probable cause that's, So I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand? If I find that you're a danger to my public, I only have one place for you. So don't. That includes everything. Do you understand, Mr. Husband? You mind filing no weapons, please?
Yes, Judge.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're ducking, you're dodging, you pick up a new case, it's not going to go well for you. You understand? All right, I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box and get your bond conditions. We'll have you sign it, and then you're free to go. All right?
Yes.
Mr. Williams, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 8th, 2025, the officers were dispatched to a disturbance call. The officer met with the complainant, who stated that she and the defendant were in a 7-month relationship. The complainant stated that she shoved the defendant with her shoulder and that the defendant then grabbed her and threw her around. The complainant advised that the defendant was grabbing her face and neck area and has pushed her to the ground, causing pain. The officer observed a laceration on the complainant's hand and a swollen lip. The officer made contact with the defendant, who stated that he lost control and that he admitted to shoving the complainant.
Williams, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand? If you have contact with this person, if I find that you're in possession of a weapon, I'm going to revoke your bond, put you in jail. No more PR bonds. I want my community safe. I don't care who it is, what color they are, whether they're a small farm animal. I don't care. Everyone gets protected. Do you understand? Do you have the ability to hire a lawyer, Mr. Williams? Okay, I will take a look at an affidavit. I'll see whether you qualify, and then I'll have you take a seat in the jury box. I'll have you sign a reset with Victoria now. Do not leave until you sign our bond conditions. Do you understand? And then I'll have you talk to a lawyer here momentarily.
I work with her, so
I'm sorry?
she worked at the same.
That's going to be an issue. I don't want you to have contact with her. Actions have consequences. Did you get appointed to Mr. Williams?
Yes, Your Honor.
Great. I wanted you to look at probable cause to see if you guys had any issues with it. That's why, or wait, no, maybe that was another case. Okay, tell me.
We were approaching, there's a MOEP and bond conditions that have no contact. The parties no longer live together, but they work at the same place, and there's a chance that their schedules could coincide with each other. State's okay with no threatening and harassing, but.
Have you reached out to the complaining witness? Do you
Yes,
know?
so, I mean, she's not on board, regardless, but I confirmed that they don't live together, so my suggestion was to have no threatening or harassing, that way both of them can work.
But I want to make sure that
The re-
she's, protected, that she doesn't have any kind of fear.
Yeah, she's not really concerned, from my understanding, but, I would suggest, just keeping the residency restrictions so that, because they don't live together,
Mr. Williams, come up.
and then just, keep the no threatening or harassing contact for that purpose.
Good morning. So your lawyers asked for me to modify your bond conditions to say no threatening or harassing. I will acquiesce, but you have to understand what is threatening or harassing. Doesn't matter what you think. It's what she perceives. So if I'm going like this, is that threatening or harassing? It most certainly is, and it can get you in trouble. I don't know what kind of relationship you have with this person, but if it's the type where you're constantly butting heads, you got to be careful. There are many, many vindictive people in this world, and you never know if all they got to do is call, hey man, he's doing this, he's doing that, and then you're going to end up back. So you got to be careful. You understand? Okay. So the only thing I'm doing is I'm modifying the conditions so no threatening or harassing contact. The residential restriction will still apply. So you cannot go to the house listed in the order for protection. Any more questions, anything?
No, Your Honor.
Okay. All right. Good luck.
Judge, do you want me to refile that? Because I know the language that's typically in there.
Yeah, I would, just in case. So it's like nice and clean. Yeah.
Sounds good. I'll file that now.
Thank you, Judge.
Oh, and no weapons too.
Yes, sir.
Okay. Mr. Camacho, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, officers were dispatched to Hardy Road in Harris County, Texas, in regard to a minor crash, failure to stop and give information call. Upon arrival, the officer spoke with the complainant, who was also in police uniform. The complainant stated he was driving on the freeway when another vehicle got into his lane and cut him off to make the exit. The defendant got over and hit the front right panel of his truck with the back driver's side of the defendant's vehicle. The complainant followed the defendant, who had his hazards on, but the defendant did not pull over. The complainant continued to follow the defendant's vehicle until the 911 operator told him to stop following. The complainant gave a description of the defendant's vehicle, and a license plate number to the dispatcher. The complainant pulled over and waited for the officers to make a report with an estimated damage of $2,000. The officers ran the license plate and found the vehicle registered to an address on Skinner Road, and the officers traveled to the location and met with the defendant and his father. The officers were given consent to enter the property to look at the vehicle and observe damage. The defendant stated he was crossing the lane to get over because there was an opening and that the truck accelerated and hit him. The defendant stated the complainant already hit him and was close behind him, so he kept going. The defendant stated he turned down his street and the complainant kept going. The defendant's address is approximately 7 miles from where the accident occurred.
Okay.
And so, Judge, if I may, the complainant was only stopped following him while he had his hazards because he was told on the 911 call. And also, I see on the summary that when they run his license plates, license plate GS9711 is missing a letter. License plates are usually 3 letters, 3 and 3 numbers. So I'm not sure how running the license plates will go to his house. And additionally, if the correct license plates were also run, then it would actually show that he's not the owner of the vehicle. So I'm not sure how they were able to identify.
Well, somehow they got to the house, right?
Yes, Judge. They ran it and they got to an address and they went there and met with the defendant.
And then he states that he was driving, right? And the collision occurred, and then he took off. Your license plate, I have no idea. I mean, did they have the full license plate or did they not?
Your Honor, at this time, I don't know. The DIMS just states as counsel said, just GS 9711. So I don't know in the full offense report if it says the full license plate number, but either way, they ran a license plate and they returned.
Somehow they were able to get it to him. I don't know. I mean, if you discover something later that's different, come back and we can revisit probable cause. I'm happy to do it at any time.
Yes, Judge. And so the reason I say that is because I have the tags for that vehicle, and that's not the license plates that we have on the summary. And that's
I mean, really, we'd have to set it for a formal hearing.
Okay, Judge.
Because I have to give them time to be able to respond to that as well, you know,
That's
because
fine.
that's more, I mean, this is just a mere probable cause here.
Your Honor, in the OR, there is the complete license plate. It's the RSG and it continues on. So
I'll check on that, yeah. That's fine, Judge.
So you're saying it was in the DIMS?
in the DIMS, it was missing a letter, but in the full OR, they have the complete license number.
You know, pull the 911 tapes, see what the 911 tape
We'll wait
says,
for
right?
that,
It may
Judge.
be different, as, you know, maybe they'll have the whole thing on the 911 tape, you know?
Yes, Judge.
So, Mr. Camacho, I'm going to find that there's probable cause to go forward with your case. Have you run his license? See, he has a valid license.
Correct, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
That is a condition of your bond. So if I find that you're driving and you don't have a license or you don't have insurance, I'm going to revoke your bond. I'll put you in jail. No more PR bonds.
Eligible, Your Honor.
You understand?
Yes, sir.
Okay, now you have a lawyer. Good job having a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. You don't have to come back to court. She'll let you know when you have to come back to court. All right? All right, I'm going to have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks. Yes, ma'am.